Good morning. So this is, I would say, a very hot button topic. We've got, a lot of green on our backgrounds and a lot of green to be concerned about. But I would say this has come up in two venues for our clients, both in as the employer, how you should probably handle all of this, and as the owner who has a premises that the public is coming to, and what you can do in those scenarios. So I know there's a lot of confusion, there's a lot of rollout, there's a lot of questions. So today we're hoping to cover some of those as we can right now, and we'll delve a little more into that later. But this is something that is changing, has changed already, and will continue to change as we kind of see how New York rolls all of this out. So with that being said, I would love to pass it over to Colin so he can get us started on problem number one and some of the solutions and how to handle things.
Good morning, and thanks, Chrissy, for the intro. Just as you all know, New York's passed this very significant piece of legislation joining all the other states that have already legalized recreational marijuana. And crucially, part of this law has very directly impacted employment decisions and employment actions relative to marijuana. So my focus in presenting to you is going to be on the employment related issues surrounding this brand new law, and which will no doubt be a major impact to all of your businesses. In regards to employment, under the new cannabis law, it is now unlawful for an employer to refuse to hire, employ, license, fire, or discriminate against an individual in their compensation, promotion, or terms of employment because of an individual's use of cannabis in a legal recreational setting. This means cannabis use outside of the employee's work hours, off the employer's premises, and without the use of the employer's equipment or property. That's crucial. I think an initial knee-jerk reaction to the legalization of marijuana might be, oh boy, people are going to be smoking at work or around work. The law does not authorize smoking at work or even possessing marijuana at work. So this is that's a crucial distinction that all employers should be paying attention to. In terms of what can an employer do, an employer can take action whenever they determine that an employee is impaired by the use of cannabis. So this is a crucial two-part test that I'm about to discuss. Impaired means that the employee manifests specific articulable symptoms and that those symptoms decrease the employee's performance or duties. I think it's going to be really important for employers to pay attention to both sides of that equation, because it's possible that employees may argue that to the extent that they're ever caught displaying symptoms, that they don't interfere with their performance or duties. So this is going to put a real onus on employers, proper documentation, strong observation, following best practices with regard to reviewing crucial situations where an employee manifests symptoms that they you believe are related to marijuana. And I'll talk a little bit more about best practices there later on. Other places, the other parts of this is that if the symptoms the employee displays interfere with your duty to provide a safe and healthy workplace, you can take action. If the employee's symptoms or actions are somehow in violation of state or federal law, that's another place you can take action against an employee without violating this law. A good example of that is an employee who holds a commercial driver's license. As many of you may know, the Department of Transportation has to issue those licenses following drug testing, and cannabis is still a Schedule I drug. Therefore, any employee that tests positive for marijuana, be it medical, recreational, or otherwise, is deemed unable to hold a CDL. In that circumstance, if holding a CDL is an essential part of an employee's position, you could take action without violating this law. Main considerations for employers. First, every company that employees should have a handbook setting forth company policies. If your handbook happens to have a zero tolerance policy for drug use on or off duty, you need to revisit that policy, because it's likely that your policy will violate the new law. If you can still prohibit the possession and use of marijuana on property and during the work time, but you're no longer going to be able to prohibit off-duty use unless there's a state or federal law reason for doing so. So go revisit the CDL example I just gave. It will be crucial going forward that employers take a hard look at your policies. If you need assistance with your policies, you should consult an attorney. We obviously do that regularly here at the town law firm. And make sure that you have you're fully in compliance from a policy perspective with this revised law. Number two, testing issues. So testing is a real issue under this law in more ways than one. So I could see a circumstance where if an employee gets into an accident, being it driving a forklift or a company van, and then test positive for marijuana, it's not going to be immediately apparent that the employee you will be able to lawfully discipline that individual for their positive test alone. The key thing to look for will be if as proximate to that accident, whether the employee displayed symptoms relative to marijuana use. And so that's going to be, I think you're going to have to take a symptoms-based approach versus they tested positive, so we're gonna discipline them. I think this stems largely from the inadequacy of existing testing for marijuana. Our best understanding of the testing offerings these days are that they can determine whether someone has smoked marijuana, but not necessarily whether it was immediately prior to whatever the intervening event was that led to the test. So you have to show great care in how you address testing issues and any positive test. And this is going to be a place where I think employers are going to want to be really careful, especially in the early days as we're feeling our way through this process, to make sure you have good counsel relative to these issues, because knee-jerk reactions and quick decisions could lead to some substantial liability. With regard to non-discrimination, so just as always, employers always have to be careful not to discriminate against employees. And now you've got a new thing to worry about, and whether you're going to be alleged to have discriminated against an employee based on their off-duty recreational use of marijuana. That was no law. That was not a concern prior to this law. I can see circumstances where this may be at least there will be attempted abuse potentially by an employee who's maybe already on a warning or dealing with performance issues, who may alert coworkers to their recreational use as a means of trying to shield themselves from further discipline. That will be a challenge to address. It really puts an emphasis back on the usual stuff, which is make sure your documentation's good. Make sure you're always documenting performance issues and you're following up in a timely manner on to illustrate that employees are suffering from performance issues. If you're really good about that stuff, then issues like I just raised become less of an issue. The other thing I would urge a significant amount of care around is the search for articulable symptoms. It's very possible that in looking for articulable symptoms of marijuana use, you may inadvertently pick up on symptoms which may be the result of something else, potentially a disability, potentially the use of prescription medication based on a condition. I would urge caution that, make sure that before you make a decision, you make a decision based on the whole circumstance. And I would certainly urge you to follow best practices as you would if an employee is showing signs of being under the influence of any intoxicating substance before you take action. This is one way to avoid an unnecessary discrimination allegation. With regard to disability accommodation, this is a good time to remind you that marijuana is also has medicinal uses that are authorized in New York State. So while you have to accommodate off-duty use, it's still not a reasonable accommodation to allow employees to be high on the job, just like it is not a reasonable accommodation to allow people to be drunk on the job, even if they suffer from alcoholism, which is potentially a disability under the law. So, keep that on the front of your radar. So, in terms of safety, I think this will have the biggest impact on safety-sensitive positions. The law is going to put a real premium on employers with safety-sensitive jobs, figuring out and getting educated on what the articulable symptoms of marijuana use are. You're going to want to take in as much information in that sphere as possible, so that when you're making an evaluation of an employee who is acting maybe oddly or strangely, or exhibiting the kind of things that you might associate with marijuana use, you're doing so with best industry practices in mind. I assume that will be a major cottage industry, determining what are the appropriate articulable symptoms for marijuana following the release of this law, as I think it's going to be front and center on employers' minds. I do want to also emphasize, again, it's key to follow best practices in determining whether symptoms should be addressed, and then how should they be addressed. Remember, you shouldn't meet with employees one-on-one regarding these types of situations. You should always meet in pairs of management representatives. Ideally, you have 2 management representatives observe the employee before you make a determination as to what to do next. You document that in the form of a written statement. You then bring the employee into the office, give them an opportunity to address the situation so that they can perhaps give an explanation that may or may not make sense as to why they're acting in a manner that may appear as though they are suffering from or exhibiting symptoms of marijuana use. This gives you an opportunity to head off, again, misunderstanding about why an employee may be acting in the manner that you find concerning. And as a reminder, not just as with alcohol, if you think somebody is high on the job, don't send them home in their car. Make sure you call them an Uber. Last thing you want to do is put an impaired person behind the wheel. One last piece, the landscape here is changing. We've got the new law in place, but as mentioned in the intro by Chrissy, things are going to change. It's highly likely that we will have more clarity. There may even be local ordinances aimed at addressing some of the issues I've raised. And I think the picture will change, within the next year or two, so that there will be. So I would urge employers to stay vigilant, pay attention to what's going on, because I'm sure that the landscape will change as time goes on. Again, as I've given you some best practice advice already, but I think a challenge people are going to face is how do I deal with people who either don't manifest symptoms or manifest mild symptoms of marijuana use. Is this truly? Do you treat this? How do you treat it? Like cigarettes or like alcohol? There are some businesses where people will go out and have a drink during lunch and then come back to work. Like one beer during lunch. Does that that usually will not intoxicate an individual, but it may not be appropriate nonetheless. Smoking on a lunch break should probably be treated in the same manner if you tolerate people having a beer at lunch, if they were to have were to do a very minimal amount of marijuana at lunch and don't either articulate very minimal symptoms. I think that's going to be a challenging zone. Again, you do not have to tolerate people being high on the job, and you do not have to tolerate people being drunk on the job. I think that is a key aspect of this. But there's certainly going to be gray area around the sort of reduced use that I think is going to be a challenge for employers to deal with. I think that's probably going to be the most challenging aspect of this. Minimal use. Is it possible to articulate symptoms that do not decrease an employee's ability, and what do you do under that circumstance? I mean, I think that's going to be likely to be filled in either by case law and or regulation in the future, because I think it's probably going to be the hardest issue to tackle here. So on to Chrissy. That's my section on employment law. Now, Chrissy's going to talk to you about other business owner issues.
Hi, everyone. So some of this will seem slightly duplicative of what Colin had begun speaking with us about, but it's important from the perspective that you need to understand how it operates in other pieces. I'd like to start just kind of touching on some of the general things about the law that people have been questioning. And part of that has to do with exactly how much marijuana can people have. So that's one of the things that went into effect right away. So on somebody's person, if they're 21 or over, they're allowed to have up to 3 ounces of marijuana. So that's super, super duper interesting, because it makes it so that that person can, just like they could share a beer with anyone who's over 21, share any of that marijuana or edible or other thing that they have with them with somebody else. So that is something that people keep in mind. It's also something that has made people kind of concerned about where we're going moving forward, because now if one person has it, perhaps they're going to share it with others. The number one thing that I would like to say is that it is definitely still only a state law. So there's a lot of confusion about how that interacts with the state and the federal piece. So it is still illegal federally, and that's some of the stuff that Colin touched on. But you should also know that that means that technically people aren't allowed to bring it across state lines. They never could before. They can't suddenly do it now. So if they get caught transporting weed across state lines, that could be a problem. If you're a business in the hospitality industry, we often pull people from other states and locales. So that is something that can come up. So that's not something for you to enforce, but it is just something you should know generally. So if someone ever asks you about it, and you'd be surprised what customers ask you, it's still not technically legal for them to transport it from state to state. So that is the thing to know about that. So, okay, what rules are we operating under right now? So what you need to know is that right now they have, as of the enactment of this law, linked us to what is called the Clean Indoor Air Act. And why they did that is they linked us to the rules that exist for smoking. So the reason that is interesting is I know a lot of people didn't actually know what was in the Clean Indoor Air Act, and B, a lot of people weren't kind of enforcing those, on their own property. So although people, generally kind of understood, there was no smoking indoors, etc., some of the finer pieces kind of have gotten lost and weren't being enforced on private properties, even if they should. There wasn't a cop or a smoking police going around, writing tickets to businesses or people for smoking in these locations on private properties. But what does the Clean Indoor Act include? So basically, you can smoke marijuana wherever you could smoke tobacco under the Clean Indoor Air Act. And that kind of makes it difficult for people. So what that does is it prohibits smoking and vaping in almost all indoor spaces. There are some exceptions, but they're very, very limited. So for example, indoor smoking, not allowed generally in places of employment. So I couldn't start smoking anything in my office right now. Bars in New York, we banned smoking in them a long time ago. You still can't do that. If you had an enclosed swimming pool, like a covered swimming pool, you couldn't smoke at that swimming pool. If you are, waiting for a bus or you're waiting for the train, you weren't supposed to be allowed to smoke there either, because those are places where people are all kind of tightly packed together. Anything related to a school or a daycare or children, definitely no smoking. There's not supposed to be any smoking near hospitals. So all of that was for tobacco would include weed at this point as well. So part of that is, where can I smoke outside? So generally, there was already a ban on things such as parks, pools, or beaches, just kind of generally under this. Right now, if you choose to smoke weed in one of those locations, it's possible that you'd get a $50 fine. So that's something to keep in mind. There were other places that had a $25 fine. And why this is important is that if you are a business that has a campground or a beach and all of that, then you have to kind of start to enforce that. Now, I know that there are different considerations with people when it comes to weed. So you might have some kind of outdoor thing where you did the distance from the entrance, you didn't let them smoke at a playground between, sunrise and sunset, but now you're worried about weed being out there. Well, the problem is that because they tied these two together, anywhere that you allow cigarette smoking, you have to allow weed smoking. So you can't ban only weed from your campground or facility or premises or business or outside, because if you're allowing cigarettes, then you have to allow weed as well. And that's kind of a weird one. I've heard about restricting things to certain areas, and you can do that. The state themselves are going to try to create what they're calling these social consumption zones, which means that, like, if you were a landlord and you had a bunch of tenants and you were already a smoke-free building, so they couldn't smoke at home, then they could go to one of these social consumption zones and smoke there. But you have to realize that at the very crux of it, they're tied together. And why did they do that? Well, it was really an easy way for them to kind of, put the legislation out there already. We didn't have to put something new out there to say all of these places it was prohibited, because they already had something to tie to. But I realized that it's very complicated for people in the sense that they were allowing smoking, but they don't want weed in those same places. You cannot currently divorce them. Do I think that this is going to continue? I'm not sure. A lot of this law is rolling out in the next 18 months to 2 years. So we're going to see a lot of changes. Part of that is them putting this regulatory board in place. So just like, you can have 3 ounces of marijuana on your person, but you can't grow it at home yet, even though everyone knows that's coming, there's a lot of things that are still kind of in flux. So do I think that these will always stay tied together? They might not. I also think big tobacco is kind of a giant lobbyist group, if you will. And I do think in a way that if this has some ramifications, there might be some arguments about splitting them apart. But as of today, as of right now, anywhere you allow cigarette smoking, you have to allow marijuana. What makes this even trickier? If you decided suddenly to make a blanket ban for smoking on your property, period, no smoking, whatever kind that is, you could only do so for the recreational use of marijuana. This is kind of what Colin was touching on, that there's that medicinal piece and that kind of disability and accommodations piece that is different than, say, having a dry premises where you don't allow any alcohol. There's currently no like true thing baked into the law for alcohol or smoking where they say, hey, there's all these medicinal uses that allow you to do it. The reason this is particularly important is that they are discussing over the next 18 months expanding the medicinal use, both in the kinds of marijuana you can use. So does that include smoking? Does that include eating? Does that include pills? And the conditions in which it would be considered something that you would get medicinal, marijuana card, if you will, or kind of exception for, that allows you to use it in places where you might not. So that does create an interesting interplay between trying to kind of ban where things are going and do that. So what does that mean for your operation? Should you be concerned about people smoking marijuana on your property? How will you treat all of that? So that's going to be a consideration that you have to kind of just think about when you go through your business. So say you have, an outdoor event and you generally don't allow smoking within 20 feet. And so you have the smokers way back in 20 feet and you're going to allow the smokers there. So you're going to allow weed there, but you're worried because it's a family friendly event and there's a stigma with it. I hear a lot of people being worried about secondhand highs and things like that. That's not as prevalent as you would think and not as easy as you would think. I also think the other concern is that people think there's suddenly going to be a lot more weed on their campground or premises or, building or at the parks. I'd say generally the people who were smoking weed before were smoking it and, without you knowing, so they probably will still continue to do it now. But like I said before, you can't just ban it because you don't like weed as compared to smoking. They are absolutely tied together right now. So whatever you choose to do with the one, you're going to have to do with the other. So that's super, super important. How easy is it for someone to get weed right now in this state? We're still rolling that out. So technically, it's not that easy right now. You can't grow it at home yet, even though you know you're going to be able to. The dispensary licensing is a bit out. So there, it's going to take a little bit of time before you actually see this influx of weed. The other thing to know, if you didn't, is that we are heavily taxing it in New York State. So it is going to be something that, A, recoups funds for the state, but B, might be kind of a turnoff to people taking up a new habit because it'd be a very expensive habit. So I wouldn't be very alarmist about there suddenly being a huge increase, because there's a lot of things that will probably be kind of preventative to that entry. So from a premises perspective, you have to decide how you're going to treat it. So I say that it generally falls somewhere between alcohol and cigarettes. So as Colin talked about, there's impairment factors with weed that there aren't with cigarette smoking. So if you have, if you're worried about the impairment piece of it, then you're going to have to treat it the same way on that realm as you would with someone who, was very obviously impaired with alcohol. If you're worried about the smoke perspective of it and where they're allowed to do it, then you're going to have to treat it like you would, somebody who was smoking cigarettes. So it does still kind of fit in both of those realms. And so when you think about what you're doing on your property, you can do that. You could have a specific area if you wanted to create your own social consumption zone. But if you were going to do that and restrict them to that specific area, do remember again that you're restricting those other smokers to that area. So there's a lot kind of left in the air about how to handle both of these. But it is super, super duper duper important to realize that right now they are absolutely tied to smoking, these things, and you can't just do whatever you want differently about that. So I would say that is the number one concern for them, for people, and you're going to have to perhaps actually start enforcing it. So you can't selectively enforce either. You can't be like, yeah, sure, smoking's allowed in these areas, but let Bob smoke his cigarette at the playground, but not let Sally smoke her weed at the playground. Like, you're going to have to make sure that you're treating it all the same, that you have the rules that it's all the same, and that you haven't divorced the two right now. So currently they are still all tied together, and you have to keep that in mind. I know it's hard for people to wrap their heads around, especially in some of these more outdoor spaces, because smoking has been present and you haven't felt a need to regulate that. But if you're gonna try to regulate marijuana, then you have to regulate in the same fashion as smoking. So yes, even though you have a private business and a private piece of property, right now they are still tied together. And you have all of those additional concerns because there's still that medicinal disability piece that Colin talked about in the employment sphere that still is going to apply to this other piece. So if you are a public housing or a landlord and tenant, you're going to have to worry about those accommodations for that. So these are things that you're going to have to keep in mind, because it isn't just like one or the other. It kind of falls somewhere in between. Okay, is there another? Yeah, perfect. Okay. So that's kind of an overview of some of these more issues. I'd say the number one thing still is to just kind of keep in mind that we don't know what we don't know yet. So a lot of this is still new. The fines for usage are really small, as I said, like $25 and $50. The locations are very clear in the Indoor Air Act. So that is something to keep in mind. You can very easily find them online. Before, it was about smoking and vaping in particular. There were special circumstances. There were things where you could get a waiver and things like that. I'm not quite sure how that's necessarily going to apply to weed, and I don't think people are generally concerned about getting a waiver for people to be allowed to smoke weed where they're not, but do understand that because it's kind of linked together, there might be that possibility as well. So I hate to say it, but we're still in kind of a standby mode. Yes, weed can be present. Yes, they can smoke it right now, and it's not an issue, but do know that we have some time with this regulatory board going into place and everything else that might actually put some of this in flux and kind of change things around. So from that perspective, that's kind of an overview of kind of where we're at. And if you want to, chuck some questions at us, now would be the time.
We do have one.
Yeah, this is an excellent question from Thomas O'Connor. So the question is, under the Drug-Free Act of 1988, all grantees other than the states and state agencies are required to make a drug-free certification for each grant. Does this apply to businesses that received pandemic relief grants, the PPP and EIDL, et cetera? So this is a very good question. I do not believe that the PPP certifications included this, but that might be a place that further clarity is needed, because historically the SBA has required those who take grants of $100,000 or more, that's the contracts of $100,000 or more, any grant from the federal government, to certify that they will comply with the Drug-Free Act, Workplace Act of 1988. So it is that's a very good question, and unfortunately I don't think there's a very I don't have a specific answer for you today, but I think that is a place everyone should expect further clarity in the near future, because I'm sure New York businesses will be very interested in that result, since so many businesses did take such grants.
So I would also comment that I think this still has to do with the intersection we were talking about between state and kind of federal law there. I think that's the piece, right? So this is a law that we passed in New York, but as Colin had spoken about before, there's still, even with the Clean Indoor Air Act, if it's federal property and stuff like that, things get treated a little bit differently. So I would say that there's probably going to be an interaction of that. Now, as we knew,
there's potentially it's in this instance, it could be a place where New York State's permissive nature is preempted. It just depends. It's definitely a place where I think it's a place where we should expect further clarity.
Absolutely. And I'd say that let's talk nationally. Things have changed a lot since 1988. These other states that, kind of put in legalized marijuana and other things, those weren't back in 1988 either. So I think that as we see more states do something at the state level, the interaction with the illegality at the federal level is probably going to have a lot of push and pull, I'd say. So not just in the realm of applying to grants, but kind of everything to deal with where those kind of piece together.
I will say, if you look at Massachusetts law, for example, who has legalized recreational marijuana, places who are federal contractors still must certify that they have a drug-free workplace. And for example, public schools in New York will be subject to the same requirements because they're federal contractors. And I think that'll be an interesting place where this law's angle will require further clarification. But I think one point to make further about this is that not every business drug tests. I mean, and in fact, I think but for safety sensitive work, drug testing is becoming less and less in the marketplace. So, how an employer would come to find out that an employee is doing off-duty marijuana use is, with absent random drug testing, it may be that you would never know. So from a practical standpoint, it may be sort of educational.
Yeah, I mean, some of this is baked into the state law, and when they lumped together with the Clean Indoor Air Act, from the perspective that they already had some protections for government buildings, public school buildings, et cetera, in regards to smoking and things like that. So I think that's perhaps how they tried to address some of this interplay with the federal law, is that there was already a ban on that on those properties for generalized smoking. So perhaps kind of that's how they're going to do that. But so I guess still TBD, unfortunately, but yes, there is going to be some pushback between the two. Um, I see a question about kind of how did New York follow the other states in drafting this new law and what other issues have kind of come up. So from the premises perspective, I can say that a lot of the issues that have come up haven't been huge issues. And some of the people I've talked to in Colorado and California and things like that, colleagues, that I knew, it wasn't as big a deal when it rolled out as they thought it would be. So they had this, it legalized things, but just like, drinking is generally in bars, weed smoking was generally, near these dispensaries or these, kind of social clubs they had from that. So from that perspective, it wasn't suddenly a huge influx of people trying to come to properties that they shouldn't to do weed smoking. So I'd say from that perspective, they weren't very concerned about it. The other thing I had heard is it's regulation, regulation, regulation. So since we're still waiting on our regulatory board and there's still some flux of regulations, and how they're going to roll things out. I think that's the piece we're still waiting on. That is a bit more settled now in these other states, is that they have an idea of their framework, where we're still kind of, in that shifting and changing landscape right now. Colin, do you have anything to add to that one?
No, I think in terms of, I'm not aware, I haven't studied those many other states' marijuana laws in terms of whether they've had the same employment related prohibition. If you look at this, New York's New York added recreational marijuana use to its pre-existing law that banned employment decisions based on off-duty cigarette smoking and alcohol use. So again, I think you just treat it the same way. If you treat it like alcohol, which is the other intoxicating substance on that list, I think it's instructive. You focus on, are they impaired at work by the substance? Are they articulating symptoms that get in the way of their work performance in a safe workplace? And if you stay within those lines, it will be that's the place you want to be as an employer.
I mean, to be frank, we've had medicinal marijuana legally for a while now. So like some of those problems have already been there if they were there. I mean, New York City, even prior to this new enactment, had a ban, frankly, on testing for weed within New York City, not just the testing and the use of those results, the testing itself. So, I mean, this has been kind of hovering around from the medicinal realm for a while now. So now that we're in this recreational piece is when it's suddenly on more people's radars. But I know even like 2-3 years ago, contractors and people and forklift operators and the scaffolding law, people were all very concerned about the intersection between, kind of contractor work and medicinal marijuana. So I think if we haven't seen, huge issues right now in that medicinal sphere, that, it's just going to be handled in the same way, right? So those people had a medical reason that they were allowed to use marijuana in their off time. But once they entered that premises, as Colin had said, that impairment and that safety piece, still kind of trumped that. So I don't think that, again, I don't think that it's going to be a huge issue. It wasn't a huge issue in these other places. I mean, I went to law school in California where there was a medicinal weed doctor on every corner trying to give someone weed before it was legalized. And, it still wasn't such a huge deal that it affected, every part of life. So I think that with these regulations and stuff like that, what it truly did was get the states more money and actually kind of put a framework together. It didn't, suddenly change the way employers or people who had a semi-quasi public property had to do business. So I think that's kind of the lesson that can be learned from some of these other states. It didn't make a huge difference in their day-to-day. So yes, to be determined what our regulations are, but I don't think we're going to suddenly see a radical shift, overnight. All right. See, if a 21-year-old shares with underage individuals, what should we do? Any advice? That one is,
Well, if it's your employee and they're sharing with an underage individual, I'd say that's a disciplinable offense. But I don't know if that was the context of that question.
I think that's a good place to also take it. I mean, again, I think this is where we talk about how it sits between alcohol and smoking. It's what would you do if you knew you had an employee or a person there who was 21 and you knew that they were sharing alcohol with someone that wasn't 21? So if it was just like generally and you had a party atmosphere, that's why you have those bars and things that ID people before they come in. So you're not a bar and you're not that, but generally if people aren't 21, you can make a comment, you can say something. Are they going to do it behind your back if they really want to? Probably, but they were doing that with alcohol already. You shouldn't encourage it. You shouldn't make it easy for people, but you're not law enforcement. So that is a little difficult, although law enforcement's going to have quite a hard time, arresting people and things for marijuana usage now. I'd say that's probably still one of those clear-cut issues. So just like if you were suddenly worried about someone giving a bunch of alcohol to minors, it would be a very similar scenario that you'd be worried about someone giving a bunch of marijuana to minors. So I would, kind of keep that in mind. What was the policy you did if people would have given alcohol to underage people, and kind of treat it the same way? But yes, Colin, I think absolutely in an employment sphere, that's pretty clearly an egregious thing to do, and probably not protected in any way, shape, or form.
No. And the next question regarding a federal liquor license, I don't know the exact answer. If you've made a federal drug-free workplace act certification and you do random testing as required by it, and somebody tested positive for marijuana use, you'd want to be careful about what your next steps are. But I can't give you an explicit answer on that. It's, again, that may be one of the circumstances referred to in the law where if the federal law requires you to prohibit the use of medical marijuana as contractor status or as a license holder. So it's possible that's one of those exception fits, but I can't give you an explicit answer.
Yeah, I mean, I think the number one thing, as we said, is again, for the 30th time, apologies, but this is that intersection between state and federal. And because things are still illegal and banned at that federal level, that is where it's weird. I think Colin's right that, this is perhaps one of those areas where you get that leeway. I also think that it would generally be safer to kind of just prohibit it if you can. I know that means that if you weren't prohibiting smoking, you're going to have to take that in, but I wouldn't want to be the guinea pig and I wouldn't want to be the test case. So I'll let someone else test that law out in that interaction. And I would just, from a safety and a doom and gloom perspective, if you will, go to the side of not allowing it, and thus not, allowing smoking, frankly, just to not be the person who has to test the interaction between these two kind of laws.
Yeah, I don't know. I would be careful about, I'd be careful to go back and look at your certifications that you made in association with getting that license in the first place, figure out what your obligations are under your certifications, then figure out whether or not the specific terms of the certification bar recreational use as opposed to on-duty possession or use. So all things to take into consideration, but I think we'll learn more as this rolls out.
So I think that's a great place to kind of wrap this up. As we're wrapping it up, if you have any last minute question, feel free to throw it in there. Because this is something that is absolutely on our radar, both from the employment perspective and kind of what to do with guest tenants, et cetera. We try to put updates and out there both on our news page and via emails and things like that. So if that's something you want to be a part of, then make sure you're part of our email list if you weren't before. So that way, when Kate rolls out the updates as we see them, you can make sure that you're on that list so you know what's happening. As always, if you're already one of our clients, feel free to reach out to us about more specific questions for your specific business. I know sometimes that's not something that, you know, comes up when you're sitting through one of these, but something you think about later. If you're not already one of our clients, we'd love to have you become one, and I extend that offer to you as well. So as you can see, there's our contact information for Colin and I. If for some reason you can't remember this or you don't get this, you will get an email from Kate, she said on Monday, with other information, or you could always kind of reply to Kate already. I think you have her address from registering, and she does a really good job about getting it back to the person who can answer your question. So that looks like we're at about time and no new questions. So I'd like to thank everybody for joining us this morning. Sorry that it's still kind of shifting, but you have a little bit of an idea of where you're at right now. And again, if there's anything more specific you're looking for, please feel free to reach out to us. We'd love to hear from you.